Hello and welcome to another week of the CIL eAcademy, where we have on this week's topic on state responsibility, we have the honor to have with us Professor Martins Paparinskis, who I'll introduce in a moment, but I just wanted to give on behalf of Dr. Nilofer Oral and myself, as co-directors of the Academy, warm welcome to Martins, and especially a big thanks to him since he's currently in New York. And actually, Nilofer and I were also in New York. So we're 12 hours before Singapore. So that makes it a little bit early. So we're really happy to be with you and that you have accepted our invitation. That's why we also slightly adjusted the time so to make it a little bit less painful. But of course, Martins, we're so happy to have you with us. I'm with Nilofer, we now that we're colleagues in the International Law Commission, and that's of course one of the highlights of your CV. You're currently a member of the International Law Commission. We're so happy to have you as colleague and also to have you in our lecture series. So Professor Paparinskis is a professor of public international law at University College of London. Is also a member of the International Law Commission, and more importantly, is affiliated with CIL since he is the editor-in-chief of the CIL Dialogues and a global fellow at CIL. He has an interest in general international law, but a particular interest in international dispute settlement and state responsibility, as well as in the fields of investment, human rights, and environmental law. And Martins, since you had a pick in the topic, you're going to explain to us the topic that you picked from state responsibility, the law of responsibility, which is compensation and international law. And so we're looking forward to hearing from you on this topic. And again, on behalf of Nilofer and myself, big thanks for joining us today. After your presentation, of course, our participants will have an opportunity to engage with you with comments and questions. So the floor is all yours. And again, thank you so much, Martins.
Thank you very much, Professor Galval-Teles, for the very generous words of introduction. And I'm very grateful to you and Dr. Oral, my colleagues and, could I say, friends from the International Law Commission for inviting me to speak to you this morning. I'm also grateful to participants for your flexibility in moving the time to make it is a slightly even more pleasant occasion to speak with you. In the spirit of the special lecture, I will take one particular aspect of the field that you have been considering this week, the law of state responsibility, and consider it in greater detail. And again, in light with the usual format, I will speak for some 35 minutes, a bit more, to leave us some 15 minutes for questions. I will now bring up the PowerPoint slides for today. I take as a given the assumptions and distinctions in the law of state responsibility that you have already addressed this week. The proposition about the distinction between primary rules of international law, which impose obligations in any substantive field of international law, be it human rights law, humanitarian law, law on the use of force, environmental law, economic law, space law, or any other, on the one hand, and secondary rules of state responsibility, on the other hand, that govern the identification of breach of primary obligations, and importantly for today's class, the legal consequences of that. I also take as a given your familiarity, and indeed probably any international lawyer's familiarity, with the key document that governs our thinking in the area, the International Law Commission's articles on state responsibility for internationally wrongful acts, adopted in 2001 on second reading, which I will refer to as the 2001 articles. And I propose to look in greater detail today at one particular aspect of the law governing the legal consequences of state responsibility, with a particular focus on compensation. And in the tripartite structure of law of state responsibility, which governs in the first part of ILC articles responsibility itself, in the second half legal consequences, or to use the Commission's technical jargon, content of responsibility, and in the third part, implementation of responsibility, compensation falls within the second part. It is an important consequence of state responsibility. And here you have the outline of things that I want to touch upon today, some in greater detail, others more fleetingly, but very happy to pick any aspect up in the questions that I want to talk you through. Why is compensation important? In a way, why did I choose as a topic for this week? Say a bit about the historical development, which is very important in this field, understanding why rules are formulated in the way they are, and then introduce or probably remind us a number of concepts and distinctions that are relevant in the area, being equipped with the historical and analytical tools. We would tackle rules provided directly in the ILC articles, particularly Article 36, which explicitly deals with compensation, as well as other relevant rules of the articles, which are to some extent contiguous to the particular rule on compensation and complement its content. So, why is compensation important? You have on the screen a quote from a great and much missed international lawyer, professor, judge, and the final special rapporteur on state responsibility, James Crawford. A quote taken from his Hudson Medal lecture that he delivered to the American Society of International Law. And I think that the point that Professor Crawford was making, if put more generally, really speaks perhaps to the reality of international law of responsibility. Of course, many aspects are important. It is very important to know when responsibility arises, how it can be implemented, and so on. But it is extremely important in practice to advise states on what the, as it were, remedial consequences for the breach of international law is going to be. And compensation is an aspect that is a bit more transposable in various fields of international law than other forms of reparation like restitution and satisfaction. So why is it important? The practical, the eminently pragmatic answer of Professor Crawford was because states consider it to be important. It's an important proposition for a legal advisor of a state to explain to the minister why an international tribunal has required or rejected a request for payment for multiple $1 billion. So there's that reality of decision-making in domestic and international context, that the likelihood of paying or receiving a great amount of money concentrates the mind on analytical issues. How do we know of that importance? And here, my basic point that I want to make in this and the following slides is the increased importance of the law of compensation in decisions of international courts and tribunals. It is the case before the International Court of Justice, where I will say a few things in this slide, and it is also the case before other international courts and tribunals. And of course, with every year having more and more cases, the docket is still comparatively small if one compares it with other courts. So there may be regional courts that have dockets of tens of thousands of cases. That would not be the case with the International Court of Justice. But if we see at its approach to compensation, there is a great deal of more recent attention. Classically, International Court of Justice addressed compensation only once in the 20th century, in its very first case, Corfu Channel. But even then, if we look at greater detail of the way how the judgment approached it, we learn virtually nothing about the court's thinking on compensation, because Albania did not appear before the court. And the issue was settled essentially by assessing the plausibility of expert assessments submitted by the United Kingdom. So we know very little about the court's general thinking about state responsibility that could be applicable in other settings outside courts. Again, a point that you would know from the general discussion is that state responsibility is, if I may use a term that I may be somewhat overusing, agnostic on the institutional framework through which it is implemented. State responsibility may be implemented through international courts and tribunals, where states ask international courts and tribunals to recognize breach and award compensation, but also and mostly in informalized setting, where states present claims directly. And so for that setting, the fact that the international court could assess an expert report by a non-absent party doesn't help us at all. International got a bit closer to the issue of compensation in the case that, when I was a student, was referred to as the Nicaragua case. Although nowadays there being quite a few Nicaragua cases, one probably has to use a fuller title of military and paramilitary activities in and out Nicaragua to identify the case properly. You will know, of course, that the court found jurisdiction, and it found the United States responsible for having committed several breaches of international law, but it never proceeded to compensation. Nicaragua did submit a memorial on compensation, but eventually the case was discontinued. And I think that there have been some interesting recent developments where Nicaragua has noted, correctly in my view in legal terms, that even though we discontinue the particular procedure, it does not mean that it waived the right to claim a reparation. So I think here we also come back again to the distinction between implementation before a particular procedural mechanism and the content of secondary rules in more general terms. But again, 20th century leaves us wanting. 21st century is more helpful. 21st century so far has provided us with 3 judgments in 3 different fields of international law. First, in 2010, a case between Equatorial Guinea and DRC, the Diallo case, regarding human rights breaches, then certain activities carried out by Nicaragua in relation to environmental damage, and finally, last year, armed activities on the territory of the Congo regarding a variety of claims for compensation in the broader setting of military conflict, so involving breaches of rules on humanitarian law, human rights law, and use of force. And early this year, the United States was found responsible for having breached the Treaty of Amity with Iran, and court noting that compensation issues would be considered at a later stage. And this is something that has increased salience, increased normality in legal reasoning. 3 new cases were introduced during this summer, all of which specifically invoke compensation. This is not peculiar to International Court of Justice. I will not go through all the cases in this matter. I imagine that you would have been pointed to the very helpful United Nations materials on state responsibility, which in its second edition are available online, which contain compilation of excerpts from decisions of courts and tribunals that deal with particular articles on state responsibility. So if you put in your search mechanisms, UN materials on state responsibility, the first hit is likely to be that. And if you go to Article 36, you will see a few dozen pages dealing with the treatment by courts and tribunals of Article 36 in the context of ITLOS, in the context of arbitration, particularly law of the sea arbitration, as well as several cases of interstate character before human rights, as well as one of the important developments of international law since the 1990s, the comparative rise in importance of cases and fields of international law that deal with claims by non-state actors. So they are human rights regimes, African, American, and European, as well as investor-state arbitration. But also, this is something that is not limited just to judicial practice. This is something that is also being discussed before and by international organizations relating to damages registers. The more familiar one will probably be the Palestinian Damages Register that was established by the General Assembly after the advisory opinion of the International Court relating to the Israeli war, and more recently the discussion regarding the establishment in the regional context of Europe, the Register of Damages relating to Ukraine. And arguments are also presented in other settings. For example, this summer, there was a very interesting report published in particular setting of Jamaica that providing for an argument for the valuation for a possible claim for reparation for transatlantic chattel slavery by the United Kingdom, suggesting that multiple $1 trillion would constitute that compensation. So, in short, these things are important. We know that they are important because states consider them to be important. They increasingly put claims before them, before international courts. And you probably would have got a sense of the reality of international law in these settings, that we can look at international courts. I'm sorry, I think I got a message from one student that they can't hear me. Could I have a nod from I think I'm seeing nods from Daniel Pakpachan, who I think that am I right in reading that you can hear me?
Yes, Martins, we can hear you. So I think it's okay. Might be a problem with one of the participants. We'll try to check that.
Splendid. Thank you very much. Right. Just to conclude the point here, what I was trying to say is that international courts, we can think of them as the tip of the iceberg. If cases are brought by states before international courts, it means that for every case brought, there will be a couple of dozen states that are either preparing or dreading a particular type of claim and seriously thinking about the legal implications through it. Many cases are there, but many more cases are no doubt percolating through the international legal order. What is the historical background? Well, there are a couple of examples of attempts by the international community as constituted in the particular time to capture the rules on compensation. And probably the legal expression will not strike you as particularly unique. This is something that has been formulated in all these settings by reference in particular to the analogy of domestic private law claims. So tort claims or daily claims, and we see here the sense of the usual questions that arise in these settings, bilateral relationship, causality, injury, and damage, and also the implicit conceptual assumption taken from private law. You would have heard the tension between private and public elements in the law state responsibility. So this is distinctly a private frame. One thing, and I think that is something that I do find particularly fascinating about the field, is a point of timing, and that is where the CF comes from in the title. We are looking particularly at the 2001 articles on state responsibility. But recall from my story that 20th century is a rather meager provider of authority. So there is the interesting tension. On the one hand, articles are very influential. On the other hand, most of the directly relevant practice on the issue has arisen after the adoption of the ILC articles. So there may be perhaps a need for greater granularity in elaboration of rules and also identification of the good examples of application in these years. So how do we approach Article 36 and surrounding provisions, which seem deceptively simple? It is just 2 sentences, the second one of them not a particularly long one. The first point, and I think what I want to make here, is that Article 36 is embedded within the broader system of Part 2 that deals with content of responsibility, but also more generally the law of state responsibility as such. So to know the rules on compensation, we have to read Article 36 together with other rules. We have to also consider Article 31 that explains to us the full reparation concept, within which compensation together with restitution and satisfaction constituted elements. Article 33 tells us the very important practical question of whether this is something that is also legally relevant in contexts other than states. And then we have all the other forms and elements that stand side by side or condition compensation. And of course, this fits in the broader context. We take as a given that responsibility has arisen, that a breach has occurred by conduct attributable to the state. So this is agnostic to the question and conditions of responsibility arising. We take as a given that that has happened, and we find ourselves in the important realm of Part 2. Let me speak through a few important conceptual distinctions that help us here before we look at the particular language. The first is the distinction between compensation on the one hand, so essentially corrective justice mechanism in terms of broader purpose pursued, trying to restore the relationship to the situation it would have occupied if the wrongful act had not taken place. And if we jump back, this seems to be what Article 36 in its paragraph 1 is getting at, against punishment. A legal regime familiar to us from a variety of systems of domestic law, where punitive or exemplary remedies are familiar. So I'm speaking from the United States. The United States is one of the domestic legal systems which have such a type of remedy. Here, an important point is that international law is very clearly, legally and formally speaking, it comes across from the work of the Commission and from the overwhelming reactions by most states, is compensatory rather than punitive in character. And you have quotes from several cases, including the DRC and Uganda case, which is particularly pertinent here. And as you can see, the court emphasizes in the beginning, in view of the circumstances of the case. And the substance of the case related to armed conflict, and the court had found Uganda to have breached several obligations of international law of considerable importance, very likely some of them reflective of rules of jus cogens character. But even then, even in that setting, a purely compensatory approach was the one that was adopted by the court. So again, the tension between the private and possible other broader public considerations, which are implemented in law of state responsibility through concepts such as erga omnes and obligations of other states not to provide aid or assistance or recognition, do not extend to compensation, even if the breach is of a rule of fundamental importance for the international community. Compensation is the remedy that is provided. And similarly, in the 2022 draft conclusions in relation to jus cogens, the International Law Commission has an interesting statement, an interesting sentence that you have there, but even it at most preserves it as a savings clause. On other points, International Law Commission in the provisions and in the commentaries was quite explicit of the consequences. Nothing here. So it is compensation that we are looking at. It is compensation, moreover, for wrongful acts. For us to be brought into the realm of state responsibility, we need to have wrongfulness. There are rules of international law that require compensation as a matter of primary obligation. So the proposition that international law may require for conduct to be lawful to compensation to be provided. And there are many examples in several fields of international law. The International Law Commission's commentary particularly emphasized international investment law, but another aspect very prominent in pending litigation before international courts is international environmental law, particularly in the context of climate change law, primary rules in relating to loss, and primary rules relating to provision of compensation and addressing harm may themselves require payment. So that is also something that law of state responsibility does not tell us anything about. These are matters to be dealt and conditioned by primary rules themselves. The third point is the distinction between general rules of state responsibility that are applicable in all breaches of specialized fields. Again, the intellectual approach going back to Roberto Ago and perfected by James Crawford of taking breaches of all types of rules as giving rise to a singular regime of state responsibility, a distinction that I have always found comes perhaps slightly more easily to a civil trade in mind than common law trade carrying on with particular breach. This is something that we have also in relation to remedies and compensation. At the same time, particular fields have particular authorities and particular good examples. And this is, I think, reflected very, very nicely in the international court's three cases that I mentioned. In the human rights context, where the international court had to deal with determination of compensation regarding the breach of human rights regarding unlawful expulsion, it drew upon the best practices in the decisions of a variety of bodies, including international courts and tribunals and regional courts. And so it is not surprising that here, in identifying and applying the general rules, judicial bodies and states will turn to the best examples in the particular fields. And the added point that follows from it is that these would be different sorts of authorities in different fields. For human rights, one looks at human rights instruments. For environmental damage, something that the court addressed in the certain activities case, other types of valuation methodologies would be addressed by the court. So here, the court looked at a very different type of argument. These are the points that the International Law Commission also addressed in its principles on environmental law and on conflict. And again, in yet other settings in relation to armed conflict, like in the DRC and Uganda case, the court would look at yet other types of authorities. So human rights bodies in relation to human rights, environmental valuation methodologies in relating to environmental law, and practices of commissions and other bodies dealing with war claims in relation to war claims. I don't think that it is a particularly surprising state of affairs, but again, it responds to a basic intuition that we want to know how bodies dealing with similar matters have dealt with something. As a matter of basic analytical approach to research, that is how we would approach any matter. But for our purposes, it reflects the degree of tension. On the one hand, accepting the importance of general secondary rules, on the other hand, accepting the importance of the best practices of application in the particular field. The final important distinction is that we should think about compensation to whom and by whom. Articles on state responsibility in Part 2 deal with responsibility arising by states and owed to other states or a group of states in that setting. And so that raises several questions. What about compensation that is owed to non-state actors? And that is increasingly implemented in practice before bodies and instruments that can consider such claims. If you Google, again, the United Nations materials on state responsibility and click through the pages dedicated to Article 36, it is quite likely that most of the decisions that you will look at would have come from bodies that deal with claims by non-state actors. So clearly, there's a lot of practice in relation to compensation. And even though the International Law Commission's articles themselves, in light of the more limited scope of the project that was tasked with progressively developing and codifying law of interstate responsibility, there's a without prejudice clause in Article 33, paragraph 2. Tribunals have found it helpful, and states have overall considered it an appropriate framework to argue about the issues as well. Compensation by international organizations is something that was considered by the International Law Commission in a later project in an almost identically worded Article 36 of the 2011 articles on responsibility of international organizations, albeit with an important caveat elsewhere in the articles regarding the limited financial capacity of international organizations. And so the bigger question, which I think to some extent is left open by the International Law Commission's work, is the extent to which the character of the actor invoking or incurring responsibility affect the form of reparation. So we are ILC articles from 2001 tell us the point about the universal and holistic character of the law of responsibility in the interstate setting, and the point that it leaves open, and I think that that is where the most interesting developments occur, relates to responsibility incurred outside the interstate setting, either when those are non-state actors that bring claims, or international organizations in the view of the International Law Commission, somewhat analogous fashion dealing with them. In the remaining time, let me just say a few things about the interesting aspects of Article 36. And if you want to dwell in greater detail, I think the wonderful organizers have provided you with a draft chapter where I say a few things about particular aspects here. But let me just note a few points. This relates to the state responsible for internationally wrongful act. So that reflects the proposition I made in the beginning that this puts us in the realm of state responsibility. This does not tell us anything about the law of liability for lawful conduct in investment law, environmental law, or transboundary water law. A state is under an obligation to compensate. So this is something that is independent of particular mechanisms of invocation, implementation, whether within institutions or outside. And it also makes the important normative point that if a state breaches international law, it has to provide reparation. Legally speaking, it is not up to the injured actor to bring a claim, even though that is how things are likely to happen in reality of international relations. But legally speaking, it is the obligation of the actor that has breached. It is in a sense automatic. It is independent of the procedures provided in Part 3 and elsewhere. It is only damage which is caused by the wrongful act, and causality may raise many complicated questions, as the case between DRC and Uganda showed. And also, compensation is not the primary remedy. It is a fallback if restitution is insufficient. And that reflects the important insight by Judge Crawford that compensation, while important, cannot be the primary remedy, because otherwise it would enable the richer states to essentially buy the breach of international law. And the normative position of the ILC is that compliance and restitution, factual or juridical, with that compliance is the best possible option. Compensation, while hugely important in practice, is only fallback. The second, and I think this is where I think really the very pragmatic quote of James Crawford from the beginning hits the road. Here there are important considerations of valuation. I will not go further here, simply to say that these are things that, as we saw from the international courts judgments, are different in different fields. So different fields would have different best practices in these matters. Human rights, environmental law, and war claims have different best practices. And it is likely that the claims for damages in the pending certain assets case between Iran and United States will raise, again, very different authorities. These are not the only rules that are relevant. There are other rules that are expressed in different places, and again, probably reflective of basic familiar propositions from your private law studies. The idea that the injured actor has to mitigate damage as much as possible. And if they could have mitigated it, but did not mitigate, then it is likely to be diminished. The fact that the injured actor might themselves have contributed to damage, and that might again be taken into account. So what does that leave us with? And let me suggest 5 takeaways, or possibly 4. or 4.5. The first is to reiterate my original point about the increasing importance of compensation in state practice, in practice by and through international organizations, and practice of international courts and tribunals in the sense of decisions by international courts and tribunals. I think looking at the way how international legal order is structured, this is not likely to change soon. If anything, it is increasing pace. So it's important to be cognizant of the importance of these matters, as it were, the second layer of international judicialization that started in the 1990s, the international compensification of international law, if I could coin a very unattractive concept. The second point is the importance of the International Law Commission's work. And this is something that has really permeated the international legal order in the area, but questions remain. Questions remain on the granularity of particular rules within the field, as well as application in practice. What are the best examples? A challenge that is very hard to pin down, particularly in the context of decentralized international law. And finally, to pull it back up and consider the broader question, what are the ultimate ends of the law of compensation? As I said, classically, and also in modern law, it is viewed as reflecting this corrective justice framing that would be very fitting in an introductory civil law or private claims or tort law book. And it doesn't really engage to a major extent with a broader multilateral structure that could perhaps in some cases arguably limit compensation if it is likely to be disproportionate or take into account some broader remedial consequences for other actors. That is not what positive law states at the time, but I think in light of the greater multilateral shift of international, have to keep that proposition in mind. And that, dear students, concludes my lecture today, and I very much look forward to your reactions and questions.
Thank you so much, Martin. Thank you for having picked this specific aspect of the law of state responsibility that, as you said, is of great importance to states and indeed maybe has not been fully developed yet by the ILC draft articles from 2001 and could deserve also in light of recent developments in terms of the case law of the ICJ and other courts and tribunals be more further developed. So we have already a couple of questions, both in the chat and the Q&A. There's one question just very briefly asking, how do states pay compensation? Another question more concerned with the issue of the meaning of compensation for any material loss. And one question also about the, let me check, a more complex question. So maybe I'll ask you to start with the easier, I don't know if it's easier, how the states pay compensation, and then we could move to the issue of compensation for any material loss. But I would also invite our participants to put their hands up and also ask their questions live if they want. So please, Martins, go ahead.
Thank you, Patricia. All great questions, and I think none of them are, they're all hard in the sense that they all put finger on a particular interesting aspect of the field. Compensation is usually paid in the way how monetary considerations are interchanged in modern world. So it can simply be a transfer in the particular interstate setting. There may be very hard questions raised if particular states are under the regime of sanctions. And in the particular setting of the Iran-United States Claims Tribunal, that has raised historically certain questions about the ability of United States to provide compensation and itself be in compliance with the rules. So there are some famous examples with bags of money and such. And I think that there have been similar examples in the context of United Kingdom. But I think as a general proposition, these special consequences apart, the practicalities of payment have not really raised particular issues. And indeed, before the International Court of Justice, when compensation has been awarded in these three cases, in Diallo and Costa Rica and Nicaragua, it has been provided. And in DRC and Uganda, the court has provided, because of the magnitude of the sum awarded, it had been split in a number of parts. So these are the sort of practicalities of how to deal with things that are likely to be explicitly addressed before the court and provided by the court, in a sense that the court is informed by the pleadings of parties on the matter. At the same time, I think it's also the case, that courts ultimately try to be as helpful and easy to provide decisions that can be implemented, but not necessarily dealing with all the finer print. I mean, ultimately, it is a broader system of international law that has to answer these questions. I think that the second question that Patricia introduced was a question in the Q&A section regarding material loss in Article 27. And that is a very good question. It is the one concept that seems to some extent stand aside from the distinction I introduced between compensation for the breach of international law, that's their responsibility deals with, and compensation within the context of lawful alliance with obligations that it does not, and that falls under the specialist fields of international law. Article 27 suggests that successful invocation of circumstances precluding wrongfulness is without prejudice to a material loss being addressed. This is not something that builds on very heavy state practice or judicial practice. And it is also not something that has been addressed in a great deal of practice after the adoption of the ILC articles. In a way, the second reading on this particular point is even a bit less clear than the first reading, because if you recall from your class on circumstance precluding wrongfulness, it is at a somewhat disjointed motley crew of circumstances which don't really have a clear overreaching theme. We have consent, force majeure, distress, necessity, self-defense, and countermeasures. And so, I mean, I think simply thinking about it, one can appreciate that rules, for example, on consent would raise very different considerations than those on countermeasures. And I think that the general thinking there is probably, and that seems to have been the conception, that there are certain circumstances, and necessity is particularly introduced here, where the real purpose is to provide a bit of a breathing space for the state, rather than necessarily enable it to fully get out of the obligation of payment, which, as the question very properly pinpoints, leaves us in a slightly odd situation when the obligation and the regime itself is directed at compensation in practice, as international investment law usually is. So I think that the question is right to identify one of the points when international law is somewhat uncertain And if we read the commentaries to Article 27, we see that it is actually based on an authority that the special rapporteur was intimately familiar with, the Gabčíkovo-Nađimaros dispute between Slovakia, where he was one of the counsel. But ultimately, what the Commission relied on was not a statement by the court, but rather the offer by one of the parties indicated a concession in the pleadings that if its submission on necessity were accepted, it would still bear loss. So in a way, it is a position of a party that was ultimately not considered on the merits by the court because arguments based on necessity were accepted. So I think that this is one of those TBC things. And we have to, authors such as Federica Padeur, for example, have written very insightfully that it raises really the broader questions of what we think circumstances precluding wrongfulness are about justifying conduct in some way, saying that it is right, or is it about excusing conduct? And it might be fairly hard to provide a general answer there. The third question relates to Ethiopia Claims Commission, and the question notes that it was considered an interstate setting and point that there is a follow-up domestic litigation. And I think this is, again, a truly excellent question, which puts the finger on the fit of the classic interstate regime within which states, so to speak, pick up the claims by the nationals or other actors regarding the mistreatment of which they can exercise responsibility, bring the claims, and then also receive the compensation. And international law, and that is an interesting question, whether that is still the correct position, traditionally did not say anything about that. So there may be rules of domestic law, there may be rules of human rights law, perhaps regional human rights law, that do tell us something about it, but international law traditionally did not say anything. International Law Commission's articles on diplomatic protection suggest in Article 19 recommended good practice in that regard, that states should consider distributing compensation to the injured actors. And it is interesting, and again worthy of reflection, that in the concluding paragraphs in Diallo and DRC Uganda cases, the court noted, without quite saying that that was an international obligation, but it noted that ultimately compensation was awarded for the benefit of particular injured actors. And indeed, in the DRC Uganda case, it noted the commitment of DRC to provide injured communities and injured actors with that compensation. But again, this is something that appears to raise somewhat multilateral considerations, which present a degree of tension with traditional international law that is broadly accepted as positive and reflective of international law.
Thank you very much, Martins. I think you've replied to the three questions that we had both in the chat and the Q&A. With that brought us to the perfect timing for ending our lecture. We don't want to hold you up because I know you have another commitment early in the morning in New York, and we've already made you work quite a lot this morning. So I think it's time to close this lecture. But before doing that, let me again reiterate our thanks and our warm gratitude to you. I hope that participants enjoy the lecture. I mean, it's been very complimentary to the work that was being done yesterday by Professor Bodo Livinek, and that will continue tomorrow, also working with the participants. And compensation has been less on the spotlight, but still very, very important from the practical point of view, and also as the questions to you demonstrated. So again, on behalf of Nilofer and myself, thank you so much, Martins, and see you see you at the UN building in a little bit. I think Nilofer is
I just
there.
wanted to say thank you as well. Yeah, I just wanted to say thank you as well, and just underline to our participants that Professor Paparinskis is really a world authority on this issue. So we're very, very privileged to have him wake up so early in the morning from New York and share his time and valuable knowledge with us. So thank you so much, Martins.